My name's Alex Barthet. I'm a board-certified construction attorney. I work with my father. We have 10 lawyers in downtown Miami. All we do is construction. We help construction companies deal with contracts, liens, bonds, collections. But today we're going to talk about how to stay out of court. 3 do's and 3 don'ts to stay out of court. And it doesn't just apply to construction firms, but so let's get started here. So number 1, sounds obvious. You'd be surprised how many people come to my office and they tell me, well, I don't have anything in writing. So rule number 1, get it in writing. Why do you want to get it in writing? It sounds obvious. It minimizes any misunderstandings that may exist between the parties. Number 2, it avoids convenient memories. So to the extent you have a writing confirming your understanding, then it eliminates the ability for someone later to say, I never said that. I never agreed to that. That was never in my scope of work. You can also get better terms in writing than you can if you just have a handshake. And I'll give you a few examples. So number 1 is interest. If someone owes you money and they don't pay their bill, you're entitled to, under Florida law, recover interest on that amount. Now, if you put in your contract an interest rate, most people usually pick 18%, which is the maximum allowed by law, which is 1.5% per month, you can recover that to the extent that they don't pay the bill and you are entitled to be paid. If you don't have a written agreement and you don't put in an interest rate, then the default interest rate in Florida currently is about 4.75%. Big difference between 18% and 4.75. So if you have a writing, you can include an interest rate. After people ask me my name, the next thing they ask me is, well, if I have to sue someone, Alex, how do I reimburse myself for the fees that I have to pay you, right? Because you're expensive, you send your kids to private school. So how do we do that? How do we get our fees back if I have to sue somebody? There's only 2 ways to do it in the state of Florida. You have a written agreement that says that the prevailing party is entitled to recover their legal fees. That's why you want a written agreement that says the prevailing party is entitled to recover their legal fees. Or you sue someone for breaching or violating a statute, or you sue someone for violating a statute, a law on the books, and that statute says the winner gets their legal fees. So those are the only 2 ways in the state of Florida that you're able to recover your attorney's fees. There are clients that come to me and they have a relatively small case, and the problem is, I was actually speaking to someone on the phone right before this, and he installs closets, and he's owed $11,000, which is a lot of money for a small business to be owed $11,000, and the other side wants to hold back $4,000. Problem, he doesn't have a written agreement. So if he decides to hire me or somebody else, and then he spends lots of money litigating the case, even if he wins, even if he gets all his $11,000, he's going to have to cut off the top whatever he pays his lawyer because he's not entitled to recover those legal fees. So you want to have a written agreement. You want to include terms that are good for you in your agreement. And one of them is the right to recover legal fees and interest. Next, you want to use your form of the contract to control the negotiations. Generally speaking, whoever starts with the form of the agreement will end up with a better version of the contract at the end because you would end up negotiating off of that form. So if you can create a standard agreement for your business, and by the way, it doesn't have to be complicated. It could be a page that has the most relevant terms and conditions that favor you and protect you. But once you have that and you start from that place, rather than going to someone and saying, well, give me your contract and we'll look at that, you will always end up in a better place if you start with your own contract. It is worth spending what is probably a relatively small amount, $500 to $1,500, give or take, will get you a contract that is designed for you, that you will use for years. And it is cheap insurance when you have a problem. Because when you have a problem and you don't have an agreement that favors you, what ends up happening is you start kicking yourself because, if I had a contract that provided for the other side giving me certificates of insurance, which I never got, the other side having to indemnify me in case they do something wrong, which is not in a handshake deal. So, number one, absolutely get your agreement in writing. Spend the time to get an attorney specializing in the field that you work in to put together a contract for you. Next, understand what is in your contract. Again, seems obvious, but lots of people come to me. I had a client come into my office about a month ago, and he came into my office and he sat down and he put a contract on my desk and he said, all right, Alex, I signed it. What does it say? I said, well, there's nothing I can do for you now, right? You know that. He says, I know. I should have called you yesterday before I signed it. So you have to read and understand what's in your contract. So let's talk about what should be in your contract to protect you. You should include in your contract the scope of work you intend to provide. You should be detailed. If you're going to provide a specific thing by model number, list that. The more detail, the better. People come to me because there's a problem, and that problem usually stems from a misunderstanding about what should have been done in that contract. Those things almost always are something the client probably could have anticipated, but didn't take the time to list any exclusions or assumptions in their contract. So, in your business, there are things that you know that you don't do, that are not in your price, that your price is premised upon. My price is premised upon, the site being available to work, that I'm a foundation contractor, that there's only 2 feet of muck and not 6 feet of muck, right? Those are the types of things that you want to list as assumptions and exclusions in your contract. It may kill the deal because now you're stating the obvious of what may be a problem in the future. But isn't it better to know now about a problem that's going to happen later than to not say anything and then have to deal with it when that assumption or that exclusion comes into play? So again, think about your business. Think about, in the last 12 to 24 months, where were the pain points? What were the things that people complained about? And list them in your contract. So the next time someone shows up and says, oh wait, I thought that was included, you can flip the contract over and you can say, no, paragraph 6E says that that's not part of my contract. Understand and clarify change orders. This is a big deal in construction. So in construction, changes happen all the time. Maybe the site is different than expected. Something happens with the plans and specifications. So you need to be prepared for changes in the course of your construction contract, because that's where most of the disputes come into play. So if you know that that's where the disputes are, then you want to make sure that you understand the change order process. How are change orders going to be approved? How are they going to be accepted? Do you do the work before you start the change order? The answer is no, by the way. Do you submit your change order and then wait until you get it approved? You have to look at to see what your contract says. How are you going to get paid? That's the next thing you need to understand. How are you going to get paid? What are the terms and conditions of payment? And how well are they articulated in your contract? You need to know what are the steps in order to be paid so that you can make sure you check all the boxes and get paid. Your contract should not be ambiguous about when you get paid. A couple of things to keep in mind. If you trigger payment on a series of events, you have to be aware that it's possible that those events may not occur, right? So as an example, if you are in construction and you say my final payment is due upon the issuance of a certificate of occupancy, well, what happens if you can't get the CO because the designer that's been hired by the owner hasn't done what they needed to do, right? So think about worst case scenarios when it comes to payment and try to account for those in the course of your contract drafting. You're always better off using a date, a point in time on the calendar, than you are a triggering event. If you're the person getting paid, by the way, and to the extent you are reviewing a contract where you have to pay somebody, ideally you want it the other way around. So if I have a contract with an owner, I want to say that my final payment is due at the earlier of certificate of occupancy or June 7th. That makes it very clear when I'm going to get paid. If I'm going to hire a subcontractor, maybe I'm going to hire a plumber, I want to say that I don't have to pay you until you close out your permits. And then I don't want to put a date, right? So remember, there's two sides to every contract. You want to remember which side you're on. In construction, we deal with a contract term that's called pay when paid, which is pretty unique to construction. What it means is generally if the owner doesn't pay the contractor doesn't have to pay the subs and all the way down the line, which is a tremendous shifting of the risk associated with getting paid in construction. You need to understand if your contract has a pay when paid provision. To the extent you do work with anybody that's at all sophisticated, I would tell you that it probably has a pay when paid provision in it. So if you're thinking, well, it says I'm going to get paid in 30 days after submission of my payment application for a construction contract, well, if it also says that that's subject to the owner paying the contractor, that could be a problem. So understand when and how you're going to get paid. This is especially important in construction, but also has applications in other parts in other industries, but is to include the right to stop work. Most construction contracts that we see actually say that if we have a dispute, and even if I'm not paid, I have to keep working, and I can start the dispute resolution process. Now that dispute resolution process may mean that we go to mediation, maybe we go to court, maybe we go to arbitration, but I have to keep working. I have to keep paying my labor. I have to keep supplying materials to the job. That's a difficult thing to do for most businesses, especially a small business, right? So you're not getting paid, and now you have to pay a lawyer to fight to get paid while you're still doing the job. So one of the things you want to do in your construction contract, but again, even to the extent you have a different type of business, you want to make sure that you include an express right to stop work. What does that mean? That means that it says that if you haven't been paid in a certain amount of time, 15 days, 30 days, 60 days, that you have the right to stop working. It doesn't guarantee that you'll get paid. It just stops the bleeding. So for our construction clients that are typically subcontractors and below, this is a provision we would typically add to their contract, or a right to stop work. And then let's talk about how disputes get resolved generally. There's 3, maybe 4 ways to resolve a dispute. So one, and typically the first one, is a meeting of executives, right? So there's a dispute as between you and me. The first step of the dispute resolution process could be we have to meet within a certain amount of time, and then we have to talk about it and try to resolve it. If that doesn't work, Then we go to mediation. Now again, all of these are contract terms. None of this is required by the law. But it's good because if you can get a dispute resolved quickly, you're always better off than having that fight linger on and pay legal fees. So the next step after a meeting of executives would be mediation. Mediation is a process where the parties get together, they hire a third-party neutral, typically a retired judge or maybe an attorney who just focuses on resolving disputes. And you meet, everyone splits the cost of this person, and this person has no right to decide anybody's fate. What he or she does is make everyone aware of the costs associated with having to have the fight, the strengths and weaknesses in their case. One of the things that happens that we see is that our clients, all clients, get a little blinded by their own case. They have a hard time removing themselves from the situation and realizing, wait a sec, does it make sense spending $20,000 over a $10,000 fight? Probably not, but you have to have someone help you through that process. Ideally, your attorney is telling you that, but if you have to resolve the dispute, one of the ways to maybe get it resolved more quickly is mediation. The next two are litigation and arbitration. Litigation is the default. If you and I have a handshake agreement and we have a dispute, we're going to go to court. That's litigation. A judge, paid by our taxes, is going to make a decision, or it could be decided by a jury. The process for litigation is generally slow. An average case takes between 6, if you're really lucky, and 24 months to move through the court system. To give you some perspective, for us as lawyers to have an opportunity to have the judge decide even a small issue usually takes 2 to 4 weeks before we are able to get in front of the judge. So if the other lawyer and I are unable to work something out, and we say, okay, we're going to have to go to court and have the judge decide this small issue, which takes 5 minutes of the judge's time, we're going to have that resolution is going to happen 2 to 4 weeks from now. If we need more than 5 minutes of the judge's time, it usually takes 2 to 3 months to get in front of the judge. So now just, when you understand that, now you have an appreciation of why a case may take 2 years to get resolved, because every little step where the lawyers can't work it out ends up getting in front of a judge. The benefit of litigation is that it's somewhat predictable. Cases, other prior decisions of the court, act as precedent so that other people can rely on them. So you can more comfortably say, well, I have facts in a situation similar to this case, so the result should be similar to the outcome in that case. In arbitration, you effectively hire a private judge. It's either 1 or 3. There's services that administer arbitration. The AAA is one. There's another one called JAMS. And you pay a fee, and they will connect you with arbitrators, and you pick the arbitrators with the other side. The benefit of arbitration is that it's private. It's not necessarily confidential, but it's private, so there's no public filings of anything. Number one. Number two, it is possibly faster, but not always faster, because the arbitrators can take a long time too. One of the things that it almost always is more expensive, because when you pay the arbitrators, which are these private judges that your attorneys pick, these arbitrators get paid just like lawyers. So they get paid $350, $400 an hour. So every time you have one of these hearings I'm telling you about, it takes them an hour to prepare. They're on the phone with you for 20 minutes. I mean, it adds up. We have a client now who signed a contract that required arbitration with 3 arbitrators. So every time something happens, it's running at like $1,000, $1,200 an hour, plus what he's paying us, plus what the other side is paying their lawyer, and they're not. They understand how this works. The arbitrators, so they want all their money up front. So before we even started the arbitration, the arbitrators wanted from each of us, each side, a check for $25,000. So before we even start the case, my client had to write a check. By the way, he's owed $180,000, right? So he's owed $180,000. He's paid us a little bit of money, and now he's got to write a check for $25,000 to this group of people so that they can decide his case. But that's what he agreed to. And if you agree in a written agreement with somebody that you're going to arbitrate your case, most judges are going to require you to arbitrate. Next, securing your right to be paid. So if you're in construction, you have the right to get paid typically with what's called a construction lien. There are certain requirements depending on where you are in the process of the construction chain on what notices you have to provide. So for most people, and the general rule is, you have to send a notice to owner within 45 days of your first work. You have to record your lien within 90 days of your last work on the job. And you have to file a lawsuit to foreclose on that lien within 1 year. If you miss any of these steps, and there's lots and lots of exclusions, by the way, to these rules and exceptions, but if you follow these rules, you should be able to secure your right to be paid with a lien. And what's a lien? A lien is an encumbrance on the property that you work on, so that if you don't get paid and you provided materials or labor to this property, and you can sell the property and any equity would belong to you up to the amount of money that you're owed. There are other ways in construction to secure your right to be paid. The other is what's called a payment bond. If you do work as a sub or below on a public job and some private jobs, that contractor may have to get what's called a payment bond. Because either the owner on a private job or because on public property you cannot put a lien, the law requires that they post security so that you get paid. The rules are pretty similar. If you have a contract, again, sub or below, you typically need to send what's called a notice to contractor within 45 days of your first work on the job. You need to send a notice of non-payment within 90 days of your last work on the job. And then you need to file suit on your payment bond claim within 1 year of your last work on the job, which is, again, the rules are similar between liens and bonds, but they're not exactly the same. So that's construction. That's how most people in construction can secure their right to be paid. But there are other ways, depending on the business that you're in or the materials and services that you provide. So don't just think, well, I don't have lien rights, so therefore I'm out of luck. You can, to the extent you provide goods, you can get a UCC1, which secures the transaction. Let me give you an example. When you go to the bank and you get a credit line, one of the documents that the bank is going to fill out and record with the Secretary of State is a UCC1, which is a document that lists all of the things that their money is encumbering. So they may give you a credit line and they may say, and now we have the first right to your accounts receivable, all your inventory, your trucks and machinery. So that's a pretty standard document that gets recorded or filed by a lender. But there's no reason you can't do the same thing. So we represent actually the only foundry in the Southeast. So they make grates and manhole covers. They're out in Medley. It's one of the oldest companies actually in the country. And they sell their grates and manhole covers across the country. And they sell it on consignment. So there are these places where they will warehouse my client's materials, and then they'll be sold from there. So they had a question. How do we secure our inventory that's sitting in someone else's warehouse on consignment? And the answer is you record a UCC1. So they are now recording UCC1s in all the states, because every state has this process. So now if something were to happen and they need to go in and they need to get their stuff back, they have the right to do it. The bank can't come in on that consignee and take back take my clients' grates and manhole covers out of the inventory to pay the debt. So think about whether or not in the business that you run, you can get a UCC1 to better protect your right to be paid. Personal guarantees are another great way to secure your right to payment. People don't like giving personal guarantees. And the reason they don't like giving it is because they want to know that if things go poorly, they can just close the business and they are no longer obligated to pay the bill. But if you are extending credit, one of the ways you can increase the likelihood of getting paid and secure the debt is to get a personal guarantee. It has to be written properly, but if you can get a personal guarantee, you are able to exert leverage to get paid. Keep in mind that in Florida is what's called a debtor state. It's generally debtor friendly. So the assets of, let's assume that you get a personal guarantee from the wife, but the husband didn't sign the personal guarantee. You can get a judgment and collect against the assets of the wife, but not of the husband. And that also includes the property that is jointly owned by the two of them. So if they own a piece of property by what's called tenants by the entirety, which is how many people hold joint property, you don't necessarily have a right to get it even though the wife may have signed your personal guarantee. So it's good to get a personal guarantee. It's great to get a personal guarantee from the husband and the wife. So keep that in mind. All right, so let's talk about some of the don'ts. Don't wait to start collecting on your accounts receivable. So what are some of the things you can do to increase the likelihood of getting paid for the bills that you send? Well, the first thing is bill regularly. If you send bills sporadically because you're busy, you didn't get to it, it's harder to get paid, right? So if you have a process in place, we send bills on the 1st of the month, on the 15th of the month. Whenever it is, you should have a process in place in your business that's when the bills are sent. I didn't get to it. Oh, I didn't get to it. And before you know it, another month goes by. That has a devastating impact on your business. One, because you're not generating that cash flow because it's going to take time to get paid anyway. So if you're waiting to send the bill, you're just adding more time on what it's going to take to get paid. Limit your credit risk. Lots of folks that come to my office, they say, well, when they owed me $25,000, I was getting nervous, but I didn't want to pull the plug because then I thought I would definitely not get paid. Well, how much are you owed now? Well, they owe me $75,000, right? So be careful about how you decide to extend credit. You should be extending credit, one, within your ability to tolerate non-payment, and two, your ability and understanding of what the risk truly is. So analyze the situation on a case-by-case basis and reanalyze it as your accounts receivable continues to grow. It is not a pleasant thing to call people and hassle them for money. Some people hate it. Some people won't do it. Other people, they tolerate it. But understand that you're invariably going to have people that owe you money. And you need to contact them. You need to call them. Don't just email them. But you do need to email them too. Because if you don't shake the tree, people are not going to pay you. We had a client, and his process for paying bills was, when I got the third call, I knew I had to write the check. I said, well, that's just not nice. And he said, there were lots of people that just stopped. They stopped calling, they stopped emailing, and that's money that he never paid. So it's not it's not good to just hope to get paid. You have to actively pursue your accounts receivable. Let's say that you know that there's a dispute associated with this account, right? So, by the way, that's probably one of the reasons why you're even delaying picking up the phone and calling, because you're like, you know, he's just going to bring up the fact that I showed up late, right? And I did. I showed up late. So resolve that dispute quickly. In writing, give a credit if you need to. We're going to talk about the credits, the way you should give credits. But come to an understanding to move forward from the dispute. And then get it in writing. You need to condition your credits. It's probably the most important thing you're going to hear me say today. Condition your credits on prompt payment. We had a client who was owed $80,000 for some work that he did and materials he supplied. The other side negotiated down $4,500 off the price. So what did he do? He issued a credit memo. Didn't say anything. It just said, credit memo, $4,500, show the new balance. What did the other side do? They still didn't pay, and they sent him a partial payment. Now I have to deal with an unconditional credit memo. There's no indication that he gave this credit just to get paid. So if you are going to issue a credit, condition it on getting paid by a date certain. So if you're owed $10,000 and you talk to the other side and they say, look, I disagree with you, but you know what? I'll take $1,000 off the bill if you pay me right away. Great. Send an email. This confirms that I will reduce our bill by $1,000 for a total balance of $9,000 so long as I am paid by May 9th, right? So May 9th comes and goes, you haven't gotten paid, guess what? It's like you never gave the credit. So remember that if you're going to give a credit to condition prompt payment, you have to put that condition in whatever writing exists that gives the credit. Avoid emotional decision making. I have a client who is arguing over $4,000. The whole case is over $4,000. They have paid me $18,000. And the case is over $4,000. Now, I know what you're thinking, right? You're thinking, well, you know, I know how lawyers work, right? But honestly, I told her, I said, look, I know you're right and they're wrong. Just write the check. Instead of giving them the 5, give them the 9 and just be done. You'll save money. Nope, I am right. He is wrong. I'm not going to let him get away with it. It's fine. You're going to end up paying me even more money than that. And, you know, 8 months later, we're still in the case and there's no end in sight. So that is emotional decision making, not business decision making. This is a business. You run a business. Make decisions based on what is best for your business. If your lawyer tells you you're going to spend more money fighting over it, then cut a deal, put your tail between your legs, and move on. Unless, of course, you're independently wealthy and you don't mind paying lawyers. We have a client like that, and they're fighting over $3,000. And I told him, I said, just so you know, you're going to spend about $50,000 with me. He said, I'm okay with that. You know, I told him, but he's fighting over $3,000 because the other guy made his wife cry. So you know what? He's going to go the distance. But remember that when you make the decision. And the other thing I will tell you is, in the manner in which you approach the situation with the other side, be careful not to paint yourself into a corner. If you tell the other side words that you cannot back out of, you may feel cornered in a way that you decide that I got to go forward with the case because I'm too proud to tell the other side that I'm going to back down. So always remember that. If you're going to make a threat, see you in court, then be ready to live by it, because the other side could say, okay. And then are you going to say, oh, geez, I was hoping he was going to counter. I guess now I got to go see him in court. So just remember that in how you deal with your negotiations. Next, don't work without insurance. To the extent you are in construction, you should hire an insurance agent that specializes in construction. If you are in any other business, you should hire an agent that specializes in that business. Just like if you hire a lawyer, you should hire a lawyer that specializes in your industry. The rules and laws are such that not having a specialist help you is a detriment. So, if you all need insurance, make sure you hire someone that can help you in your industry. You need to manage your risk with insurance. So the first thing is, do you have the proper coverages in your policy? What is the minimum coverage that you need to feel secure? And your agent is the one that's going to be able to help you with this. You need to also consider about other ways to transfer risk. So one of the ways in construction that folks transfer risk all the time is to hire someone else to do the work, right? So if you're a general contractor, you hire a subcontractor. If you're a subcontractor, you will hire a subcontractor for certain scopes of the work. In the course of negotiating and executing those contracts, you want to pass the risk that you have to take, either some or all of it, down to people further down the chain. The same is true in other businesses. To the extent you hire vendors or service providers, understand that you can pass some of your risk down to them in the contracts that you hire, in the contracts that you sign. So specifically, there's indemnity provisions. Provisions in the contract that say, if I hire you and you are the reason something goes wrong, you need to take care of the problem and you need to defend me to the extent that it drags me into it. You need to get certificates of insurance from everybody that works with or through you as an independent. So if you subcontract out any work, you should get a certificate of insurance that says that they have insurance. But in addition, you want to make sure that you get something called an additional insured endorsement. And an additional insured endorsement says that not only do I have insurance, that's what the COI does, but the additional insured status gives you the right to make a claim on their policy as if it was your policy. So it's like you have two insurance policies, the one that you paid for and the one that your subcontractor got that made you an additional insured on it. Now, sometimes you'll see in your certificate of insurance that you are an additional insured. Just know that the way that works legally can be tricky. If you have a written contract that requires that you are an additional insured under his policy, then having a certificate that says that may be enough. But if you have a handshake agreement, or if it's a third party, right? So if I'm the owner of a piece of property and I hire a general contractor and the general contractor hires a plumber, I don't have a contract with the plumber. So if I want to make a claim against that plumber's policy, I need that plumber to give me an additional insured endorsement. It's a piece of paper beyond just the certificate of insurance. So remember the distinction between a certificate of insurance and additional insured status. And one of the things that I'll tell you, and maybe this comes as a shock to you, but there are some insurance certificates that aren't real. I know, it's amazing. So someone hands you a certificate of insurance and you find out, wait a second, when it comes time to make a claim, they don't have any insurance. So a tip that you should use is if someone gives you a certificate of insurance, you should call the agent that's on it and confirm the policy. We had a client who got a certificate of insurance, picked up the phone, called the agent. The agent said, yeah, we issued a policy. And then a week later, after we gave him, I don't know, 15 certificates of insurance, he canceled the policy and we gave him a refund. So that's a problem. Now you have a certificate that doesn't have any value. And you should avoid shopping solely on price. And the reason is that unless you have a very good relationship with your agent, you need to be careful that your agent isn't giving you a policy that has very little coverage, and it just, because it has so little coverage, that's why it's cheaper. Where we saw that was clients who would get certificates of, or who would get insurance policies in construction, and they would do commercial and residential work, and then they would get a policy that was pretty cheap, but it had what's called a residential exclusion. So every job they did that was residential, they had no coverage. And they didn't know that, but the agent was able to get and bind the policy because he convinced them that he was the cheapest price. So just be aware that when you are comparing prices for insurance, that you need to have an analysis of all the policies to make sure it's an apples-to-apples comparison. I think this is the last one. Don't wait to get legal help. There are clients that come to us, and it's usually too late. We could have done a lot more had they called us early. But they said, you know what, I think I can do it myself. I don't want to spend the fee, so I'm going to deal with this problem. And then sometimes it ends up poorly for them. Had they spent, I don't know, 15 minutes, 20 minutes on the phone with us or with their lawyer, they could have avoided a much bigger problem. But now they've got, instead of dealing with the small problem, they're dealing with the big problem. So what are some of the things that a lawyer can help you with early on in the process? Form contracts. So we talked about the things that should be in your contract and those things that shouldn't be in your contract. A lawyer can help you put together that contract. Help you review the contract before signing it. So one of the things we do a lot of is clients will come to us, subcontractors, suppliers, general contractors, owners, and they'll give us a contract and they'll pay us to review it before they sign it. And we'll generate an addendum, and then they'll pass that addendum on, which is our proposed changes, to the other side, and they'll negotiate. So that's one thing you can, another thing you can do with an attorney. We talked about legal consults. Just pick up the phone and have an ability to have a conversation, to bounce some ideas off of somebody that specializes in that area of the law. And then you can always get a better deal hiring a lawyer when you don't need a lawyer. Just like you can probably get a better loan from a bank when you don't need a loan. You know, your balance sheet's going to look better. You can probably negotiate a better rate with your lawyer. If you can talk to them and convince them that you are a good client, that you're going to be, it'll be a good relationship between the two of you, then they may be more willing to help you. We had a client hire us recently, and he said, I don't need anything, but I just want to be able to know that if I have to pick up the phone and call, that you're there. And that was about 8 months ago, and he's yet to pick up the phone and call. But that's the best time to negotiate it and sign up with a lawyer, is when you don't need one. So let me tell you a little bit about a website that we run. It's called The Lien Zone. If you're in construction, it has articles, podcasts, videos, forums, all related to construction in South Florida, covering topics from liens, bonds, contracts, delays, back charges. We write an article at least once a week. So if you go to thelienzone.com, you'll be able to get lots of information and look at videos about how to get paid.